Well, hello. Welcome, house guests, and welcome to our live version of House of Chatter, our Blake Lively edition. I'm so glad you're here. So, it turns out that we have a little bit of an update. It's not actually on Blake Lively, it is actually on um, Justin Baldoni and the Wayfarer team. So I'm going to read that for you. Um, and I have it pulled up here. And Perez has already covered this, so I'm a little bit late to the party as always. But this filing is with the Supreme Court of the state of New York. And it says, caution, this document has not yet been reviewed by the county clerk. See below. Index number unassigned, received 9/30/2025. Actually, it says received NYSCEF. So this is fairly new. And right off the bat, I don't know why it says this. And if you noticed in Blake Lively's CRD complaint, it didn't have any of the headers. And that's something that Ken's pointed out. So I want to give credit to Ken's. This is quite interesting why they put this in red and why they wouldn't do that with the other court papers. You know what I mean? So if anybody has insight on that, just let me know. So I'm going to start. This is the New York Times Company plaintiff versus Wayfarer Studios LLC defendant. To the above named defendant, you are hereby summoned to answer the complaint in this action and serve a copy of your answer on the attorneys for the plaintiff within 20 days after the service of the summons, exclusive of the date of service, or within 30 days after service is complete if the summons is not personally delivered to you within the state of New York. In case of your failure to appear or answer, judgment will be taken against you by default of the relief demanded in the complaint. Trial is to be held in the New York County, New York. The basis of the venue is the location of plaintiff's principal place of business at 628th Avenue, New York, New York, 10018, and that this county is a location where a substantial part of the events giving rise to the claim occurred. And this is by David McCraw, New York Times Company, legal document. I'm just going to read you what this red footnote here. It says, this is a copy of the pleading filed electronically pursuant to the New York State Court rules. And they cite it, which at the time of its printout from the court's system electronic website had not yet been reviewed and approved by the county clerk. So the county clerk has not accepted this yet. Because the court rules authorize the county clerk to reject filings for various reasons, readers should be aware that documents bearing this legend may not have been accepted for filing by the county clerk. Caution: this document has not yet been reviewed by the county clerk. See below. So, why didn't Blake Lively's filing have some weird footnote redness all over it? Why? Anyways, just another ADD thought of mine. So here's the actual complaint. Plaintiff, the New York Times Company, the Times, by and through its attorneys, brings this complaint against defendant Wayfarer Studios, LLC, Wayfarer, and alleges as follows. This is an action brought pursuant to NY Civil Rights Law 70A and 76A to recover costs and fees and expenses incurred by the Times in defense of a defamation action brought by Wayfarer and parties associated with Wayfarer. See Lively versus Wayfarer Studios LLC et al. The consolidated action. 2. Strategic lawsuits against public participation, SLAPP suits, are lawsuits used to inhibit the exercise of free speech and to harass publishers by forcing them to expend time and resources on baseless litigation. He never said it was the judge. He never said it was baseless. He just said that there was a failure to plead the pleadings. At least that's what I thought. Is that correct? Am I wrong on that? Wow, that scared me. Sorry about that. My house is haunted. New York's New York's anti-SLAPP law offers redress to targets of SLAPP suits. On November 10, 2020, New York's governor signed Assembly Bill 5991A into law, substantially expanding New York's existing anti-SLAPP law to provide greater protection to publishers against frivolous, that would be a keyword, litigation intended to silence their exercise of the rights of free speech and petition about matters of public interest. What about the free press? Under New York's anti-SLAPP law, defendants in lawsuits involving public petition and participation, i.e., SLAPP suits, may now file an action to recover damages, including costs and attorney's fees from any person who commenced or continued such an action without a substantial basis in fact and law. Well, maybe that's why they're bringing it to the Supreme Court, because it's continued and there's no like ending to that or resolution. I don't know, not a lawyer. The anti-SLAPP law also provides for I'm going to butcher this, compensatory and punitive damages against plaintiffs who, like Wayfarer, commence or continue meritless legal claims for the purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the exercise of free speech. I wonder, harassing is, I always like to read between the lines, and I'll always read like further way into it and jump to conclusions. But I'm wondering if like there's something going behind the scenes, maybe for like criminal charges or something, and Wayfarer is like saying, "Hey, New York Times, I know that you guys were colluding with each other at least since October 31st, because that's what the metadata said." So maybe they're kind of like foreshadowing that. The anti-SLAPP law, 5. The anti-SLAPP law applies to lawsuits targeting any communication in a place open to the public or public forum in connection with an issue of public interest or any other lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest. The term public interest defined broadly to mean any subject other than a purely private matter. New York Civil Rights Law 76A 1AD. But, public interest, any communication, or any other lawful conduct. I wonder if that's the subpoena that they're trying to get out of. It is now well established that news coverage of matters of public interest fall within the scope of the law. Yeah, because you didn't make it, you made it a public interest because you reported it when there was a private messages going back and forth. The Times is a New York corporation with its principal place of business at 628th Avenue, New York, New York. The Times is a publisher of the New York Times and www.newyorktimes.com. Upon information and belief, Wayfarer is organized as a limited liability corporation under the laws of the state of Delaware, with its principal place of business in Los Angeles, California. This court has jurisdiction pursuant to New York civil practice law and rules. The basis of this claim is that Wayfarer tortiously commenced and continued a SLAPP suit against the Times. Venue is proper pursuant to CPLR 503A and C because the Times' principal place of business is in New York County. Venue is also proper because Wayfarer tortiously commenced and continued the slap suit that is the basis of the claim in New York County. Facts. On December 21st, 2024, The Times published a news article authored by Megan Twohey, Mike McIntyre, and Julie Tate titled "We Can Bury Anyone" inside a Hollywood smear machine. The article and accompanying video. The article and video reported on a sexual harassment and workplace retaliation complaint filed by actor Blake Lively with the California Civil Rights Department, the CRD complaint, in connection with her work on the film It Ends With Us, which was produced by Wayfarer. The produced by Wayfarer. Miss Lively filed the CRD complaint against Justin Baldoni, who directed and starred in the film and co-founded Wayfarer, and Jamie Heath, Wayfarer CEO, the film's lead producer. The CRD complaint incorporated documents including text messages, emails, communications between Mr. Baldoni, his publicist Jennifer Abel, and a crisis PR specialist, Melissa Nathan. The article and video explicitly relied and cited to the CRD complaint, and the documents referenced therein to report on Miss Lively's allegation that Mr. Baldoni and Mr. Heath engaged on misconduct on the set of the film, and that Mr. Baldoni's subsequently engaged Miss Nathan to tarnish Lively's reputation. On December 31st, 2024, Wayfarer and its affiliates filed suit against the Times in California State Court for defamation of false light arising out of the publication of the article. See Wayfarer Studios LLC et al. Versus New York Times Company, Los Angeles Superior Court. This complaint was never served. So if they can say that, use that as evidence, why wouldn't they be able to use the Van Sham? Anyways, on December 31st, 2024, Miss Lively filed suit against Wayfarer, as well as Mr. Baldoni, Mr. Heath, Steve Sarowitz, Ends With Us Movie LLC, Miss Nathan, the Agency Group PR LLC, and Miss Abel in the United States District Court of District Court for the Southern District of New York. See Lively versus Wayfarer Studios LLC et et al. On January 16, 2025, Wayfarer, along with Mr. Baldoni, Mr. Heath, Mr. Sarowitz, It Ends With Us Movie LLC, Miss Nathan, the Agency PR LLC, and Miss Abel filed a lawsuit against Miss Lively, Ryan Reynolds, Leslie Sloans, and Vision PR Inc. in the United States Court for Southern District of New York. The action. Wayfarer Studios LLC et al. Versus Lively. They're giving this the docket numbers. On January 30th, 2025, the action was consolidated with Miss Lively's lawsuit. The consolidated action. Wayfarer and its affiliates did not originally name the Times as a party in this case. On January 31, 2025, Wayfarer and its affiliates filed an amended complaint naming the Times as a defendant in the consolidated action. The amended complaint. The amended complaint, Wayfarer and its affiliates asserted 4 causes of action against the Times. And I totally forgot about this. And I definitely came into this case like in May. So I'm like way behind the 8 ball. So Sorry, guys, about that. But it says, first, Wayfarer and its affiliates asserted a claim for defamation against the Times for reporting that it had engaged in, permitted, and or failed to report sexually inappropriate conduct towards Lively and retaliate against Lively for reporting the harassment by propagating false and misleading narratives about her for the purpose of damaging her image and reputation. Okay. Okay. The amended complaint specifically challenged a single concrete statement from the Times video, which said that Baldoni and Heath hired a crisis PR manager who orchestrated a smear campaign against Lively. Well, couldn't that be proven? That could be proven not true because they weren't worried about that. They were worried about something else. They were worried about the Swifties. Okay, next, Wayfarer and its affiliates asserted a claim for false light against the Times. The false light claim was based on the same statement as the defamation claim. Okay. And finally, the amended complaint asserted claims for promissory fraud and breach of implied contract against the Times. Those claims were based on a December 2024 email from the Times seeking comment from Wayfarer and its affiliates before publication of the article. The email requested that they provide the Times with a response by noon 2020 or by noon December 2024. I don't think this helps them, and this is why. So listen, the email requested that they provide the Times with a response by noon on December 21st, 2024. The Times published the article at 10:11 a.m. on December 21, 2024. So they admit that I'm just reading this again. So they're admitting that they asked, or they're admitting that they published the article at 10:11, but that they're expecting a response by noon. So they thought that they had more time, and then by the time they got to noon, they already published it. The Times published the article at 10:11 a.m. on December 21st, 2024, only after receiving comment from the attorney for Wayfarer and its affiliates. Okay. The amended complaint tried to construe the email as promising that the article would not be published before noon on December 21, 2024. But you know what? I don't even think that matters because the metadata was what, October 31. Subpoena was September 27th. Phone was August 21st. So, okay. On February, next, on February 28, 2025, the Times filed a motion to dismiss the amended complaint with prejudice pursuant to Federal R Civil, I think, P12B6, C. Lively versus Wayfarer Studios, docket 105 and 106. Following briefing on June 9th, 2025, the district court granted the Times motion and dismissed all claims against it with prejudice. Right, Exhibit B, the opinion. It is clear from the district court's opinion that the claims against the Times lacked any basis in fact or law. Okay. Preliminary, the district court held that the New York law applied to the defamation false light claims against the Times. The district court noted the statements emanated from New York, where the Times is located, and that decisively New York has a strong policy interest in regulating the conduct of its citizens and its media. First, the district court dismissed the defamation claim against the Times. As an initial matter, it held that any statements in the article and video reporting on the alleged sexual misconduct experienced by Lively were not actionable because they were based on the CRD complaint and therefore were subject to New York's fair report privilege, and separately were not plausibly made with actual malice. That I didn't even notice that, but I'm not a lawyer. I am getting really worried about them, but not in this case for sure, but in Lively's case, um, I have a little bit more hope, that I do actually hope that the judge does more favor her so that she doesn't have grounds to appeal, but Wayfarer does, and then they just bleed her all out. But that's just my opinion. And I totally forgot where I was at. Okay. As for Times statements about the smear campaign, the district court found to the extent they fell outside the privilege because they relied upon communications not included in the CRD complaint. They were not plausibly made with actual malice. The district court specifically noted that the CRD complaint and article contained numerous messages and documents strongly suggesting the Wayfarer parties did spread negative stories about Lively, and that a reader of those messages would have little doubt that the Wayfarer parties engaged in a smear campaign. That is why we're all mad. Because it's a total lie. It's just a lie. And my phone might die. The district court rejected the idea that actual malice was established by certain text messages and that the Times allegedly saw, and suggested that the negative publicity about Lively was coming from sources other than Baldoni and his associates. Those texts did not overcome the reasonable inferences to be drawn from texts indicating there was a smear campaign, even if others on their own attacked Lively online. Oh, blame everybody. The district court also noted that the article's inclusion of additional context favoring Baldoni and the prominent incorporation of the plaintiff's denials cut against an inference of actual malice. In sum, the amended complaint failed to adequately plead multiple necessary elements of a defamation claim. Second, applying the New York law, the district court dismissed the false light claim because the state does not recognize this cause of action. Finally, the district court dismissed the promissory fraud and breach of implied contract, holding that they were meritless. The district court found that no contract existed and that the email at most was a promise that Wayfarer and its affiliates had until noon to provide comment on the reporting. As the district court noted, their lawyer did just that, and his statements were included in the article. The Times incurred not less than $150,000 in legal fees and costs for defending against the lawsuit, which had no basis in law or fact. That, $150,000 just seems silly to me now because we're in like the millions. In the other case. So I'm like, hey, Times, would you like hard up for money or something? But you must be. The Times realleges, and incorporates the allegations in the foregoing paragraphs as though fully set forth within. New York's anti-SLAPP law provides that in action involving public petition and participation, a prevailing defendant shall recover damages, including costs and attorney's fees, from any person who commenced or continued such action. Costs and attorney's fees shall be recovered upon a demonstration that the action was commenced or continued without a substantial bias in fact and law and could not be supported in substantial argument for the extension, modification, or reversal of the existing law. Let me read this again. Shall be recovered upon a demonstration that the action was commenced. So they would have to show, they have to prove that? Like in a trial? The lawsuit against the Times was an action involving public petition and participation under New York civil rights laws. It was based on a news article published by the Times, communications in a public forum in connection with an issue of public interest in lawful conduct and furtherance of the exercise of constitutional right of free speech in connection with an issue of public interest. The district court's opinion makes clear that Wayfarer and its affiliates both commenced and continued the lawsuit against the Times without a substantial bias in fact and law. So I wonder if they're just doing this to end it, to get out, because she's getting out. Under such circumstances, New York anti-SLAPP law requires that Times be awarded its costs and attorney fees and other such compensatory damages as the court deems just and proper. By operation of law, Wayfarer is jointly and severely liable for the damages resulting from the baseless claims brought against the Times. Wherefore, the Times respectfully requests that this court declare that the Times is entitled to reasonable costs and attorney's fees and disbursements pursuant to NY civil rights law, or the Times its reasonable costs and attorney's fees and disbursement pursuant NY rights, an amount to be determined, and grant the Times such other and further relief as the court deems just and proper. Okay, guys, that's it. Thanks for joining me. Like, subscribe, comment, share, and let me know what else you want us to cover. All right. Thanks, guys. Thanks, house guests, and have a great day.